if you find personal information about a judicial officer, it's just you can't post it online or let somebody else post it online and you adopt it on your own website. That's not cool.
Court of the State of Nevada is now in session. Honorable Barry Breslow presiding.
Thank you, Deputy. Good afternoon, everyone. Please have a seat. Okay, we're on the record in case number CO 19-1535B, State of Nevada versus Stewart Handte. Mr. Handte is here. Good afternoon. His attorney, Mr. Day, prosecutor, Mr. Stege, and Officer Cain from the State of Nevada Division of Parole and Probation. Welcome to you all. This is a time set for a hearing on a request by the division to have the court find that there has been a technical violation of Mr. Handte's probation by virtue of certain posts that he has either made or adopted or forwarded on his social media account or accounts, among other things. Just a reminder, there's been a request to allow these proceedings to be taped, audio and visual, I presume, which has been approved. Any other requests have been, I believe, granted, provided that whoever seeks to use what's happening here on their platform or for news commentary needs to go through the one main camera and video. You can't do it yourself. No personal electronic devices allowed in court to video or audio record any of the proceedings. Okay, we had a hearing 3 or 4 weeks ago based on a violation report that was filed 3 or 4 weeks before that. This hearing today has been a long time coming. Go back in time, the concern raised was not the type where the division is saying, Judge, yeah, there's been a non-technical violation, please find so, please revoke Mr. Handte's probation, have him do 4 years in prison. No, there was no such ask, and there was no conduct that would justify the ask. Instead, the ask was, Judge, please get Mr. Handte back in here, find a technical violation that occurred, remind him what he can and cannot do, because if it happens again, he runs a risk of even more severe sanctions, like jail or full revocation. The court appointed Mr. Day to make sure Mr. Handte had proper representation. There was a request somewhere along the line to have this hearing done remotely as opposed to in person. The court denied that. The court doesn't have probation revocation proceedings remote. Has never done that, and there was no cause to break from that in this case. The state filed an exhibit list and then some documents and audio recordings of evidence that they believe will be entered into court today under the Anaya versus State case from Nevada 1980 Supreme Court to justify a finding of a technical violation. In the meantime, there's been a minor flurry of filings. I believe the defense has filed a motion to postpone this hearing and or a memorandum with respect to First Amendment rights. The state has filed something in response. I have read none of that. I'm not prepared to address anything that's been filed in this case in the last 2 or 3 court days. How come? Murder trial. I was in a murder trial the last 2 weeks. I got over end of last week. And in fact, I'm picking a jury on another criminal case next week. I just got the jury veneer from the jury commissioner not more than 30 minutes ago. The court is extremely busy, and there's been no timely filed motion to postpone this hearing again, much less a response, much less a reply, much much less a request for submission that gives the court a meaningful opportunity to review and consider. So I'm not considering, I'm not granting a postponement. Second, in terms of First Amendment argument, Judge, what happened here is not actionable, it's not a violation of probation. While we're at it, you should tweak your probation order to come in line with the United States Constitution. You can make that argument today, but that's not something I have reviewed or considered. In fact, I may review or consider it once I leave the bench and issue an order on this case, or I might just make a decision here in real time. I can tell you a couple things. Number one, you're probably aware that the Anaya case and its progeny, the cases that came after, suggests that to find a probation violation to have occurred does not need to be made on beyond a reasonable doubt level of evidence. That's for criminal justice convictions. Does not need to be made on clear and convincing evidence. That's for fraud decisions. Doesn't even need to be made on preponderance of the evidence, which is civil contract type or simple negligence. It's really, palpable, reasonable, justifiable evidence, that doesn't violate notions of administration of justice or fair play. That's really the standard. I'm not eloquently articulating it, but that's the gist of it. Hearsay can be introduced, and of course people can have testimony. Mr. Handte can testify from his table, or he can come take the oath up here at the witness stand. Actually, if he's going to testify, I'll have him come up here because that way he can be cross-examined if the state chooses to do so. And then the officer can also testify if he'd like to about what he believes the evidence has shown, and then parties can make argument. I have reviewed, because I received it, early last week, state's exhibits, which are really didn't take that long to go through. From the TV show with Kevin Costner, going to the train station, we've looked at that, and then different clips of people being taken to the train station, which appears to mean they're either killed or they're there to have their body disposed. I've seen videos that other people have made that have the court's personal financial information on there, that apparently Mr. Handte either adopted or forwarded on, or at least is on his social media account. I reviewed, again, the conditions of probation. I reviewed the notice of technical violation that the division has filed, and we're prepared, the court's prepared to go forward. Now, if somebody wants to make a statement, I'm reluctant to do this at this point, either counsel, in response to anything the court has said, to see if I procedurally incorrectly identified it or misstated the law or why we're here. I'll give you the opportunity. After that, though, I'm going to look to the state and say, what do you got to prove that there's been a technical violation? So let me start with the state. What do you think we're here to do? And have I misstated anything? Then I'll ask Mr. Day.
You've not misstated anything. We're here to determine whether he has committed this or these technical violations. I would ask the court, I know those exhibits are filed, I ask that they be considered formally for purposes of this hearing, all those exhibits which were filed with the court.
Well, once somebody authenticates what they are, and I know what they purport to be, but either you're going to tell me or the officer's going to tell me, or how did this clip come to be? But we'll get to that in just a minute. But let me hear from Mr. Day if he thinks I've misstated anything or wants to object to the hearing going forward, or whatever he wants to say. Mr. Day, go ahead. Make sure the microphone is on green, please.
Yes, thank you, Your Honor. So first, as far as moving forward with the hearing today, I understand the court wanted to move forward with the hearing. I know you. So
why do you object? I mean, we've had 2 months to get ready to go here.
Well, so I'll highlight you to one issue that's a bit more unique that I haven't come across before. So here in the last few weeks, I was contacted by an out-of-state attorney, Mr. Matthew Pappas, who is a barred attorney in the state of California. He approached me that he was retained by Mr. Handte to appear along with me He would be pro hoc EJ counsel, had filed the.
If approved, right?
Correct, yes, and I've never taken part in that process before, so it's the first for me. But he paid the expedited fee with the state bar. The state bar contacted me, said that they were processing the paperwork. I think he has to do another step after that, but when he was retained, he was overseas, has a busy calendar himself. But so that is, if nothing else, that's a large basis or basis to continue. That he would like to be present as pro hoc counsel along with myself for Mr. Handte moving forward. And because I think that process just takes some time with the expedited filing. That all hasn't happened yet, so he was unavailable for today's hearing in any event. And so.
Well, I did find, is he going to work for free? I mean, you were appointed because I found Mr. Handte, I believe, legally indigent. That doesn't mean he doesn't have money. It means, enough money to live on it, or, but I found that he's entitled to an attorney at public expense, and he happens to have a very good one right here. But is the idea that he's being retained, either paid by Mr. Handte or someone on Mr. Hante's behalf?
It doesn't sound like to me that my client has personally paid him. It sounds like it's a mixture of Mr. Pappas. He likes to engage in these types of litigation, these types of issues, and possibly with some help from friends of Mr. Handte. But,
Okay, what else, what other issue?
well, so the only, I guess, real witness issue I have, so to speak, and we maybe can just dispatch with this, but as far as his California probation officers, I myself have gotten out of back-to-back jury trials in 2 different jurisdictions, played phone tag with his California probation officers a lot of times, and so I know what they would testify to. I don't have them here today under subpoena in presence to testify that Mr. Hante's doing very well, that they have no issues with him whatsoever as far as they're concerned in the state of California. That is, in essence, that is what they would testify about. So the way I view it, the court, if you would like to hear from them in person and wouldn't accept that as an officer of the court, I'm aware that that's what they would testify to. If you wanted to hear from them in person, that would be a basis.
Well, we don't, okay, but you're unable to say right now, Judge, if we rebooted this for Tuesday of next week, if you carved out a few hours of your trial time, he would be here. He said he's gonna be in town, I can make sure he's here. You just haven't heard from him, fair?
Well, I've heard from him, but not
To
to iron down an exact date he could be here. He was very interested appearing over Zoom, which I know this court doesn't love. And so, no, I don't have an exact date for you that he could be here. I would work to convince him to come here in person. I was, serve him a subpoena, try to avoid that for an out-of-state law enforcement officer. I mean, it's not as if his testimony is 2 hours long. It's that as far as they're concerned, they're working with Mr. Handte. He's in compliance.
Well, do they know what the allegations here? I mean, when you have that discussion,
They've received, my understanding, they received this report.
have you talked to them? You mean these proposed exhibits or just a report?
Just the report, but as far as, I guess, so notwithstanding the specific allegations in this violation report, as far as his behavior in California, checking in, having a job, trying his best to pay his fines on time, living in a safe environment, not getting in trouble.
Checks all those boxes.
Yes,
So, Judge, if you're not gonna postpone the trial, please accept my offer of proof.
yes.
Again, without knowledge of whether he would come to the same conclusions if he were aware that there were certain videos being posted either on Mr. Hante's social media platform or being furthered by Mr. Handte. You don't know, you've never talked to him about, is it a man or a woman, I'm sorry?
Man,
All right, have you never talked about, hey, by the way, take a look at this stuff because this is what has the Nevada Department of Division of Parole and Probation and the prosecutor and the court concerned of conduct that allegedly is occurring here? You haven't had that conversation?
No, not in detail, so no, and so to be clear, I don't know exactly what he would say as far as his reaction to it. I just meant everything else that a normal probationer is supposed to do, Mr. Handte is doing, and then we have these issues.
Okay. All right, I'm not gonna postpone the trial because there's a pro BG application that might be filed on behalf of someone who's licensed in another jurisdiction. Couple of reasons, while attorneys are able to, while clients are able to, change attorneys, it's too amorphous right now for the court to say that you're right, under the Constitution is implicated if I don't postpone the trial, is anyway impaired. Plus, these allegations have been a couple months in the system, and so, with all due respect to Mr. Handte, he knew or should have known that this day would come at some point. If he wanted a different legal representative, this is a day and time we've all had circled on our calendar. So, and again, just want to emphasize for everyone, this is a technical violation. Now, it's certainly an important one, or we wouldn't be here, or Mr. Handte and the state wouldn't be as concerned, or the probation officer. But no one is asking to revoke Mr. Hante's freedom, and in fact, I don't believe, unless something's changed, the state or the division, even if the court finds a technical violation, is gonna ask for the court to remand Mr. Handte to jail. It's just a reminder of what's allowed and what's not allowed, but I'm not gonna postpone the trial for the reasons you stated. In terms of the offer of proof, before I say I'll accept those, I wanna hear from the state in response to that last issue. Mr. Stege, what do you think?
The last issue of what the outcome of today's hearing is, the court broadcast before that if we have this hearing, all options are on the table. From the state's perspective, all options under a technical violation are on the table
Okay,
today.
including up to 30 days in jail?
Up to 30 days, forfeiture of good time credits are sort of the two pieces that the
Okay,
state has.
all right, fair enough. But no one was arguing if we didn't have this hearing for that, and no one's arguing that this is a non-technical violation, and Mr. Handte should be sent over to the Nevada Department of Corrections. All right. How about the offer of proof of what the California officer would have said?
It sounds like mitigation sort of evidence. It's not a basis in the law to revoke someone on, or to take action on a technical violation, right? You can't take action for not being employed, for failing to pay fines and fees, et cetera. It sounds more like litigation. I'm okay with a stipulation that he works, that he's making efforts towards the fine, his residence is approved. I don't accept the portion that it sort of is juxtaposed. They think he's doing fine, right? But these people are wrong. So if he can be factually specific, I like the court saying, okay, he's employed, the rest.
Mr. Handte, if I ask you some questions about your current status, you'd be placed under oath. Do you understand that?
Understand.
All right, would you please stand up and take the oath of witness? Please administer the oath of witness to Mr. Handte.
Do you solemnly swear or affirm the testimony you're about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. May you please stand, you can put your hand down. Mr. Handte, are you currently working?
No.
Do you live at a place that has been reviewed and approved by your California probation officer?
Correct.
Okay, and as far as you know, are you in good standing with your, in terms of your compacted probation in California?
I am in compliance. I met with my probation officer approximately a week ago, and he was forwarding a report to Nevada Department of Parole and Probation to recommend be terminated off probation early.
Well, that's good news for you, but I'm not sure your probation officer is aware that the probationary term here is 3 years fixed term.
Yes. We've had many discussions, Judge.
Okay, are you supporting yourself from your pension or other?
I'm struggling, but trying to get gainful employment.
Okay.
I was working as a delivery driver, and I suffered 3 separate injuries on the job. And because of the injuries, I
Had car accidents or?
fell through a floor 5 feet down
No.
and attacked by 2 dogs.
Sorry to hear
Tore
that.
my hand open, and then tore my ankle coming out of a shade into the sunlight in the driveway on a steep embankment. So I may think I'm younger than I am, but I'm not.
Well, you seem pretty fit.
That's embarrassing. That's someone's opinion. I appreciate that. But I've been looking for.
Let's get right to this, because let's just talk about this. This video about going to the train station, you understand why you've got people concerned with what's happening here, Mr. Handte? Mr. Day, I mean, I can talk to your client now, or he can be examined, or he can say, I'm not gonna testify. Or do you wanna try to work through this, so it makes some sense of all this, and doesn't involve Mr. Handte going to jail?
Yes, I mean, my intention, I mean, I appreciate the court trying to cut to the chase,
I'd like to cut to the chase, but if you say, Judge, let's have the state examine, let's hear from the state of Nevada officer. I mean, let's take a step back. If you find personal information about a judicial officer, you can look up anything you want to. It's just you can't post it online or let somebody else post it online and you adopt it on your own website. That's not cool. In addition, there's been an allegation that some direct communications or comments about a prosecutor that used to be involved in this case, Mr. Strawa, has been made. That's specifically not allowed under the terms of the probationary grant. And then the video, from the TV show, the implication is that even though Mr. Handte regularly reminds us he's not a person of advocating violence, he's not threatening direct harm, but indirectly you can't do things that make people fear for their safety. And that's a concern here. So if somebody can say, I understand your view, I didn't mean it that way, I won't do it anymore, I'll just publish things on my view of government, system, American values, the Constitution, you can do that. You just can't do something that puts people in fear that they're in harm's way. And you can't look up and post personal information about anybody related to this case. It's just off limits. Now, you can respond to that, you can say it didn't happen, you can say it happened, but it shouldn't be looked at by the court that way, or we get it and it won't happen again. What do you think, Mr. Day?
And so I think that, really in this case, it probably is better if the state goes first and present evidence. So, for example, the video that someone produced that has your Honor's personal information on it. And so,
You want to know where they got it from, because your client denies any of that?
well, it's not by him. I found a YouTube of this woman. She doesn't live here. What she does appears to be post videos about public officials and perceived corruption from state level all across the country to federal level.
And a little bit of a tutorial so people can look it up themselves, right?
Yes, I see nothing in the record that, how that's connected to my client, for example, so.
Well, let's stop right there. Officer, how do you believe, if you have an opinion, or then Mr. Stege, how is this connected to Mr. Handte? Want to go first, or Mr. Stege?
I could present evidence on that, Judge, but I do believe there is, let me present evidence on that.
Go ahead. Why don't you gentlemen have a seat just for a moment, please?
I called John Gurriere to the stand.
Okay. Please come forward. Will you please take the other witness?
Do you solemnly swear or affirm the testimony you are about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you. Deputy, make sure the green light's on. Good afternoon, sir. Please slide in, get pretty close to the microphone. Would you please tell us your name?
John Gurriere,
How do you spell your last name?
Gurriere.
Thank you. Mr. Stege.
What's your current occupation and position?
Currently employed as an intelligence analyst for the Washington County District Attorney's Office.
Are you a post-certified peace officer?
I retired from the Washington County District Attorney's Office in 2023 as a supervising investigator in good standing.
And you're familiar with the prosecution of Mr. Handte, is that correct?
Yes,
And in your capacity, you became aware that the division was interested in Mr. Handte's activities while on probation, is that correct?
yes,
And in fact, you yourself became aware of some the activities of Mr. Handte.
Yes.
Let us start with an email sent to Mr. Hicks referencing the train station situation.
So an email was forwarded to me by my chief on, I believe, August 5th.
Oh, this year?
Of this year, from Mr. Handte. It was sent to a laundry list of people to include county commissioners, court personnel, other people associated to Mr. Handte, but specifically District Attorney Hicks.
And you were aware previous to that, as a condition of Mr. Hante's probation, you should have no contact with the DA's office.
Yes.
And so, tell us, outline the contents of that email, please.
So based on the contents of that email, I was asked to look into it, and based on the perceived threat that people took from it. Specifically, Mr. Handte writes, just from the top of my head, Your Honor, these people need to be taken to the train station.
What did you interpret that to mean?
Well, I'm not very familiar with that show,
Yellowstone?
Yellowstone.
Okay.
So I had to kind of look it up. And in looking it up, posted on Mr. Hante's X account was a YouTube video of a 10-minute clip of all the people being taken to the train station. That was posted on August 1st of 2025.
So either killed or body disposed of at the train station?
That's how I represented it to my chief, is if people don't want to be, Kevin Costner's character, if he doesn't want people to be found, they're driven up to a remote location, they're murdered, and they're thrown off a cliff, never to be found again.
Near a train station?
Well, that's the reference, is the code for his crew to take somebody up to murder them, is take them to the train station.
Okay.
And that's what specifically was what Mr. Handte said in his email, that these people, or he said some of these people need to be taken to the train station.
All right, Mr. Stege can continue.
And that with, well, how did you know you're looking at Mr. Hante's X account?
I searched just a general search of Stewart Handte on X. It comes up with him with his picture. He's on an NHP uniform on an NHP motorbike.
And under that profile was a link to everyone being taken to the train station.
Correct.
And was that link referenced within the email in August that you're speaking of?
That I don't recall.
Let's move on to some of.
Hold please. So is the composite, is that exhibit 9 here?
Yes.
The composite of the different people being taken to the train station?
I believe so.
Well,
I believe that exhibit 9 is the video referencing the link from the X posting.
well, so you're asking the court to consider this for
Yeah.
the purposes of this hearing?
Yes.
Okay.
Will the court consider it?
Well, I mean, unless Mr. Day says that's the wrong thumb drive, wrong link, I've never seen it, anything like that, do you have any reason to dispute that this is what the witness is talking about?
It's a compilation video from
Yeah.
Paramount Plus.
Yeah?
No.
Okay, then for purposes of this hearing, it's admitted, and the court will consider it.
Well, and further, that is the link posted on the X account.
Well, the witness wasn't completely sure, but it sounds like that was the one, so I'll consider it as that being the one he's talking about.
Okay. Tell us more about postings on Mr. Hante's, well, how did you, as an investigator, sort of career person in law enforcement, take that posting?
Well, so after researching that and figuring out what that phrase meant in terms of how I took it from that standpoint, I did a kind of a analysis of it and sent it back to my chief, and I said, obviously, in looking, and then I had to pull up Mr. Hante's special conditions, the terms admitting, right, to make sure, is this violating this? And specifically, I believe it's special condition number 8, which you can't incite or encourage violence. Mr. Handte does make the statement, I'm not a man of violence. However, the postscript of his email does say, but please send this out to everyone far and wide, which is, it's easy to say, you know, I'm not condoning this, but send it out to anybody else. So it was kind of like not having your cake and eat it too, kind of, I guess, analogy.
Well, you're saying he's churching it up by that disclaimer at the beginning, right?
I'm sorry, dude.
The words I used was he was trying to church it up by using that disclaimer. He was trying to make it appropriate for someone to read and hopefully it wouldn't be used against him in a court proceeding. But you're saying if you look beyond that, the gist of it is, this is what he wishes upon certain people, or at least wishes would happen to him.
That was my analysis when I said it to my chief. I said that was my major concern. He kind of backs out and says, hey, I don't want anyone to get hurt, but send it far and wide to everybody else.
I understand, all right.
So that to me was a violation of that, in terms of my analysis to my chief.
What else?
To continue with sort of other postings or sort of endorsed postings on Mr. Handte's X account.
There's only one other one, I believe. If you're indicating the one about, he reposted something on his X account about politicians, what to do with them, and it's a picture of gallows, like with nooses on it, having to do with him being a victim of injustice and kind of the same narrative.
Right, and you're aware that sort of Mr. Handte has had a long sort of narrative, sort of as himself as a victim of government corruption.
Correct.
Despite himself having been in the government.
Correct.
And that posting, is that the government repair kit?
Yeah,
posting?
yes.
And that post dates the violation report.
Yes, I believe so.
And so even, right, it's called to his attention in the violation, but then posts the government repair kit being in gallows with 3 nooses.
Correct.
The judge had addressed the videos related to personal information of the judge. Is that something you yourself came across, I think it's called the Maxi Pen posting?
So that one, I'm a little, so in my position, based on the initial email that was sent, he was kind of on my radar, just to kind of just see what he's been up to. The one reference to, if you're talking about, is it a woman that's kind of talking about
Yes.
this court specifically?
Yeah, about Judge Breslow,
Okay.
property holdings, the sort of research that she did and infers sort of corruption or something like that.
My recollection was I found that on his X account. That's my recollection.
Now, wasn't there also an email where Mr. Handte sent to a number of people, including Mr. Hicks, saying, here's an important video, shows how financial corruption is taking place through the actions of attorneys and judges?
There's been, yeah, there's been multiple sovereign language that's hard to make sense of. If you're, I don't, if I can see an exhibit to clarify which one you're talking about.
Go ahead. Well, you can approach it.
I'm referring here, I believe, to Exhibit 4.
The Max Pen?
Yes.
So the Max Pen link was actually attached to, if I remember it correctly, to the email that he sent on August 4th or 5th that included the train reference, the train station reference. So in looking at that, yes, that was, again, my interpretation, nonsensical, sovereign, everyone has a trust fund, secret trust fund, trust in estates and government conspiracies. I mean, I just like, it's hard to explain.
And you're aware of some of the previous history of this case leading up to the plea in the case?
Yes.
And did you, in that context, see or observe sort of a fascination with or claims by the defendant against the court or the judge in this case surrounded these themes of sovereign citizenship, corruption, government, or negative feelings about the government.
Understatement, yes.
Understatement how.
I just, in my capacity as an investigator, when this case was going through the courts, and just recently through being, recently brought back in a part-time position as an analyst. There was a email that he sent multiple people, including Chris Hicks, that was, actually on Mr. Rebar's, social or auditing 911 account. Or
So you gestured because Mr. Rebar's here.
Yeah.
Okay, please continue.
It was a video that I believe was posted in May, or it was made in May of this year. And Mr. Handte goes into he kind of always goes into his case and.
Your Honor, I would object at this time. I believe this would violate best evidence rules. Or not. He said there's testimony about a piece of evidence that's not in evidence, not before the court, video that presumably could or does or did exist, and it's not before the court.
Mr. Stege?
Title IV of Nevada Revised Statutes, the rules of evidence apply in all proceedings but bail hearings and revocation hearings.
Okay, hold on, give me a moment. Well, I agree with the state's position, but it's a due process standard. In other words, I mean, to use terms that we all can understand, it's sort of a fundamental fairness. So if Mr. Gay says, Judge, that's not fair because he's referring to something I don't have, or you don't have in front of you, and so we're getting a little bit off base, I would say I don't quite agree, but I'll keep my antenna out. So objection overruled. You may continue to inquire of the witness about that.
Well, we please continue about sort of the Rybar-Handte connection, sort of, especially in recent times as it relates to the present allegations.
I just specifically to that one posting, or?
That plus that sort of general, I mean, the theme here is sort of belief in corruption.
So, and specific to that posting, that video, that live stream that Mr. Rebar did on his YouTube channel, Mr. Handte kind of goes into his case, which he always does. He talks about his case and the injustice of it all. And then he starts specifically talking about the death of Judge Hicks, Christopher Hicks's father, and how it was a hit and it's a conspiracy. And it was just beyond the pale to me, but I mean, so far out there. So that's one example in terms of the conspiracy. But the fact that he sent it to Chris Hicks, talking about his father.
Your Honor, I object again. There's nothing in the record. There's no evidence that he sent some video to Mr. Hicks questioning the passing of his father. I'm not saying.
Well, you can, the objection's overruled. You can cross-examine him, and if Mr. Handte wants to straighten the court out that it didn't happen or it didn't happen that way, I'll certainly take that into account.
And you are aware that sort of during the prosecution, this types of statements, sort of threatening statements, the judge called it churching the comments, right? Sort of using violent rhetoric was sort of an asterisk, a disclaimer, sort of another analogy might be a pink-colored AR-15, right? Sort of violence, sort of cloaked in non-violence. Were you aware of those concerns during the prosecution of Mr. Handte, which led to the request for the condition?
as being the investigator assigned to the case, I was very aware of a lot of the issues that were going on with him and Mr. Hillies, yes.
Sort of the violent rhetoric, sort of in the case by Mr. Handte and Mr. Hillies.
I'd have to go back to my notes in terms of the violent rhetoric. But in terms of the sovereign rhetoric, I mean, there was so much.
And by that, you mean sort of attacks on the validity of the system and belief.
The conspiracy, the cabal, everything, right?
Okay. Any other sort of Handte-specific related social media that you reviewed as it relates to the present situation?
It's, again, I believe in terms of the stuff that I've seen, there's been at least 4 emails sent directly to Mr. Hicks, amongst others, included in those blasts. August 4th, August 24th, September 8th, off the top of my head, those are the dates that were sent. The first one had to do with the sent him to the train station. Second one, or third one, had to do with the interview. He just basically just sent the link and blasted the one, but he's talking about Mr. Hicks' father. He just sent the link. The one about I believe he posted on his X account, the one about this court, the financial information, and then I believe, yeah, I think that's about, in terms of what I saw.
So your last point there, so there was on the X account, Mr. Handte posting the judicial property video on YouTube.
The only way that I would have come across that and advised my chain of command was either he sent it to us or I found it on something that he posted. So that's
One or the other.
one or the other. I mean, that's the only way I found
So
it.
let me interrupt just for a second. So here's what the court's notes are. The things that Mr. Handte did that he's not allowed to do under his probationary terms. No contact with court personnel or any official that was involved in the underlying case. No inciting to violence. And no, indirectly inciting others to violence by doctoring it up, churching it up, disclaimer, just don't do something indirectly that you're prohibited from doing directly. And then finally, he's forwarding, it seems like he's linking or forwarding or encouraging others to click so he can forward information assembled by somebody else, that somebody who finds their way to Mr. Hante's social media account on X could learn personal financial information. I want to say personal. If it's in the public domain, it's not personal, but encouraging them to take a look at somebody's personal financial information that was connected to this case. So I've got 3 things you're concerned with. Does that sound about right?
Yeah, specifically, yes,
Okay.
in terms of special condition number 1, special condition number 8.
So you understand that Mr. Handte is going to be on probation unless he does things to get himself revoked, hoping he doesn't. But if he's going to be on probation, then he's going to be off. He's going to be off in 3 years total, 2 years, I don't know. He'll be honorably or dishonorably discharged, I don't know. But at some point, these restrictions about contacting, emailing, posting things, they don't apply. They apply while he's subject to supervision by the State of Nevada Division of Parole and Probation and through compacting with California. Do we all agree with that general proposition? Or because if you thought a crime had occurred here, then somebody in theory would have charged Mr. Handte with a new crime. And that's different than violating the terms of your probation where you're prohibited from doing things that other people are able to do. You agree with that idea?
Not necessarily, Your Honor. I believe that the train station comment, at least I know one person that was involved in that email chain and they believed it was a veiled threat. So that could go toward new harassment charges toward Mr. Handte. At this point, the avenue was to, hey, is he still on probation, can this be addressed via that route?
Got it. What do you think? Same?
I agree, and, I think it's important that the court remember the history of this case, the very many times Mr. Handte was before the court, and the court sort of took a very gentle sort of chiding tone with him for much of this same violent rhetoric against public officials. I do note that condition B1, use court personnel, specifically laid out against the DA's office. That's at line 26.
I see it. I have it right up.
So
You're saying that's completely what he's not allowed to do. He
it's
did it?
completely what he's not allowed to do. The court has probably told him in this courtroom 3 times to knock off the violent rhetoric, and here we are back. I agree with the court that at some point you will be off probation, but we all know the law allows the court to craft conditions so that we can all have Mr. Handte rehabilitate himself, including this condition being tailored for a specific type of rehabilitation and understanding of what's appropriate.
Okay, 1 or 2 more questions for this, and for this witness, and I'll ask Mr. David Light to examine.
I would pass the witness.
All right, thank you. And I will say that the foundation for, virtually all the exhibits that are on this have been met. Either they're part of the court file, the witness is just identified generally if he thinks these are them, and so the court's inclined to review and consider these as part of the basis for which the division is asking for a technical violation to be found. Please continue.
Could I, well, can I ask my questions first? I would like to make a record about
Sure.
at some point what you just said.
Absolutely.
Well, I guess I'll make a record first. So I disagree with admitting, and the court consider, well, I get exhibit 9, the Paramount Plus compilation.
Right.
That's
it.
fine. But exhibit 10 and 11, I strongly disagree with. That those are videos reportedly created by Renee.
Well, but the link was on Mr. Hente's website.
It is,
Now, if you're saying that you're gonna show me why that didn't happen?
that's simply, so to my knowledge, that's not true. And I've seen no evidence that would show that that's true. I've seen the Twitter X post with the Paramount Plus link, so
Yes.
exhibit 9. That makes sense. I see a connection there, for sure. I see zero connection in Ms. Weiler's post, one of them being 8 months old, another one being, I think exhibit 11 is 3 years old. And I saw no exhibit mark that shows it's ever linked to Mr. Handte in any way, that he's
Well,
tagged it.
I thought the witnesses testified these were on Mr. Hente's X account, but you can examine them. If I have it wrong, I won't consider these in aggravation under the, for the probation revocation request.
And then, so I guess I would say the last point on that, 10, 11, I understand the court can accept testimony, but that's, again, as opposed to exhibit 9, where you have before you a exhibit that shows it, there's nothing to show in evidence any link between those videos, they're very old, but any link between them and Mr. Handte. And the broader point I'd make here is that a lot of the testimony the court just heard is not contained at all in the listed reasons we're here in the technical violation report. I looked very closely. There's basically all that testimony was just actions that happened in August of 2005. There was in fact 0 allegations for anything in August 2005 in this technical violation report. And I've done a lot of NI hearings. Sometimes I do 3 in a week. And I've never had a NI hearing where I come in and there's testimony that's not, I usually know exactly what they're going to talk about at the NI hearing, and to have testimony about, well, there's now apparently 4 emails that directly violate the probation conditions against contacting the district attorney's office. So I'm now hearing he sent 4 emails to Mr. Hicks. I only have 1 that's been marked as an exhibit. I still have a problem with that one because, again, not even listed in the technical violation report. And now for the first time I'm hearing, just from testimony, that there's 3 more. That's not even noticed at all by.
Why don't you ask the witness then if these exhibits 10 and 11 were captured from Mr. Hante's X account? Because even if they're old, videos from actions that took 8 months or 3 years ago. If Mr. Handte went out in the digital world, grabbed them, put them on his account, presumably for people to read and consider, I think they're still in play, despite their age.
All right, I'll ask you questions. Mr. Should I call you Mr. Gurriere?
However you want, Mr. Day.
So Exhibit 2, marked by Mr. Stege, was the post on X, Mr. Handte, where he's reposting the Paramount Plus compilation about the train station. You recall that?
I recall seeing it, yes.
Okay. To your knowledge, not marked before recorded evidence is any X Twitter posting linking up Mr. Handte to Renee Weiler.
I have no knowledge of that.
Well, do you recall when, well, so tell me, how did you find videos from Renee Weiler?
To be honest with you, I don't recall. I just know that, like I was trying to tell the state, he's on my radar, and anything that I see that pops up, I just forward it. And then when this hearing happened, or when this hearing was set, I was kind of just going through all my emails and just kind of saying, FYI, FYI, because I didn't know that there was an actual violation going on.
And so, and correct me if I'm wrong, part of your job, you're, as an analyst here in this case, you're trying to gather as much information about maybe ongoing conduct by person or persons relating to this case, so in this case, Judge Breslow, Mr. Handte, Mr. Stege, people like that?
Well, my current assignment, as it changes, is, in terms of how it says it, is threats and security. So threats and security to the office, threats and security to personnel, and so that's what, I mean, Mr. Handte wasn't on my radar until he sent that first email about the train station, and then I was assigned to look into it, and then more emails came in.
But so, and Miss Weiler herself, you know her at all?
No, I don't,
Do you know where she lives?
no.
Did you review her YouTube page?
I don't know if I did, I just remember, I don't know if, once I saw that reference to take him to the train station video Paramount Plus thing, if I started kind of digging deeper into Mr. Hante's X account and just seeing what he's been posting, and that's where I found it. Because I wouldn't have seen it any other, I'm racking my brain thinking how I would have seen it.
Well, it sounds, so correct me if I'm wrong, it sounds like you're looking into maybe other people who are critical of the district attorney's office as well. You just mentioned Mr. Rebar, correct?
No, not Mr. Rebar, just any threats that come in the office, and that's my kind of role.
Well, hold on, we're spending more time on this than I think we need to. Do you know if the Renee Weiler videos were captured by you to give to the division or the DA to use in this hearing, were taken from Mr. Hante's social media account, or do you not know?
I believe I sent it to Mr. Stege.
Okay, because you had it from some source,
Correct,
and you're not sure, or you don't remember, as you're sitting there, from what source you grabbed it?
correct.
Fair. Next question.
Now, regarding the first email we're talking about,
Unless Mr. Stege rehabilitates that or gets the court another reason, then I tend to agree. 10 and 11 are not in play here.
moving on to Exhibit 4, that's that August 5th email from Mr. Handte to, he called it, a large number of people, correct?
Is that the train station email?
Yes.
Yes.
Okay. And there's a lot of people, fair to say, there's a lot of people email was to, and a lot of people, even more, that it's the CC'd on the email, correct?
That's right, yeah.
Mr. Hicks is one of approximately 25 people who are CC'd, correct?
Approximately.
Okay. Now, your first review, you weren't sure what ride to the train station, what that meant?
I didn't.
fair to say, on its own, that's a pretty ambiguous statement, right?
If you don't know the show,
Right.
yeah, I mean, it was ambiguous to me. I didn't know what it meant.
And you're familiar with the phrase, you know, they should take the next train out of town, or the next bus out of town. Have you ever heard that statement, that phrase before?
In general,
Yeah.
I guess.
Okay.
I've heard a judge say that to a defendant.
Okay. And so that's, again, kind of context matters. You have to, it's open to some interpretation, right?
In terms of your example,
Yes.
I guess, yeah, I guess that could be open to interpretation.
And so it wasn't until, you didn't know exactly how to, fair to say, you didn't know exactly how to take that statement until you do further research and see that it's a quote from the show Yellowstone.
Yeah, I didn't know what the threat was, and so I simply just Googled it.
Okay. We're on the same boat, because I haven't watched that show either, but, now, you also referenced there's, Mr. Handte has had, in the history of the case, other posts that you find, odd or conspiratorial, is that fair to say?
Yes.
And that leads you to be concerned about him, is that fair to say?
It's just that in terms of my role, it's in how he's interpreting it or relating it to either who I work for or anybody that I kind of have a duty to warn, I guess. But that's what my job is right now. Not just Mr. Handte. I mean, there's a lot of other characters out there that say stuff and they send it in, so.
Right, so there are people I'm sure you see, fair amount of people are maybe displeased with one thing or another that the district attorney's office may have done or not have done, fair to say.
Yes.
And sometimes they're may not even be based in reality, is that fair to say?
That could be very fair to say, yes.
Sometimes they show lack of understanding of how the system works.
Yes.
Okay. People expressing odd ideas like that, that's not a crime, right?
No, well, again, not unless you're making statements of hurting somebody, threatening to hurt somebody, correct?
Okay. Now, did you read or review the technical violation report filed in September 2025?
I briefly read it.
To your knowledge, has there been any supplement to that technical violation report?
I don't know.
I'll pass it over, sir.
All right, thank you. Any redirect?
Do you know of any others who instantly knew the reference to being taken to the train station contained within that email?
Yeah, the person that sent it back saying this is a veiled threat, knew what that reference meant.
And,
Okay, you don't have to beat the court over the head with this. The court gets this part. But what about the information about court's mortgage or any financial records like that? How do we know they came from Mr. Hante's ex, or that he was encouraging people to click on it because he found it somewhere else, or things like that?
well, was there, so you mentioned not a lot of posts by Mr. Handte, but were there sort of other areas sort of in the social media universe where you would see sort of likes or comments by Mr. Handte?
Yeah, I mean, he's, like I said, he comments on, well, I don't wanna speculate, but I know that he's active with Mr. Rebar, comments on his YouTube channel.
Let me just say something.
Drive a little bit.
Hold on. For everyone's benefit, I don't know Mr. Rebar. Mr. Handte hasn't been charged with a crime. Mr. Handte can talk to anyone he wants to of like mind, he hasn't been charged with a crime. Been charged with violating a specific term or terms of his probation. The ones in particular are, you can't incite violence, which means obviously you can't do it yourself and you can't tell other people to do it, nor can you indirectly tell people to do it or recommend or approve. You can't do that. And the other one is, you can't contact any of the officials here. And so the concern of the court is he's been contacting possibly Mr. Hicks, he's been contacting maybe Mr. Strala, copying them on posts, things like that. So let's stay in our lane here. I realize there's more to it, but right now, let's stay right there. That would really help the court. Please continue.
I think that's about all I have for this witness, Judge. Only to note that I believe this video in question, and from the state's perspective, I see that as really tertiary, way down the list of the videos posted about Your Honor, except that they reference sort of this case, right? They're like, this judge convicted someone for taking their mother, so, and that's sort of self-contained within that. But other than that,
Okay.
I don't have questions for this.
Got it. Can we thank, were you subpoenaed or you came because somebody asked you to?
I was subpoenaed, Your Honor.
Okay, can we thank and release the witness can we thank the witness and release him from subpoena? From the state?
Yes, he should remain subject to recall.
All right, so subject to recall, the subpoena remains in effect. We'll let you know if the hearing is over and you're released from the subpoena. Thank you very much.
Thank you.
All right, who else would you like the court to hear from, or would you just make that? Division, what would you like the court to consider? And do me a favor, green light on, either stand up and address the court, that would be first choice. Why do you think Mr. Handte's violated his probation technically?
And Your Honor, I'm sorry, I'm just respectfully, if the division's gonna give like factual testimony, I think it should be sworn.
I'm trying to think if I've done that before.
It's just that, it's just that my recollection from the last hearing is that this representative from the division was not even the author of this report and didn't have
First-hand
firsthand
knowledge.
knowledge, so that's.
I usually don't require this. Mr. Stege, have you seen officers sworn at hearings like this, and if so, under what circumstances?
Typically not, but I think it's okay in this situation because there are some of the other sort of exhibits I think this witness has more information about.
Okay, officer, would you raise your hand? I'll administer an oath to you myself. Do you solemnly swear or affirm the testimony you will give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you.
Thank you. You may put your hand down. And I apologize for not standing. That was disrespectful. All right, what question would you like?
Can you tell us about, you came into possession of the email to Mr. Strala. Can you tell us sort of what you know or how you came into possession of that being former deputy DA with the Washington DA's office?
If you're going to examine the officer, I'm going to have him go to the witness stand.
Okay.
So, officer, if you please come forward. Thank you. Please slide forward. Get pretty close to the microphone. And actually adjust. Please tell us your name, spell your last name, and then please tell us who you work for.
My name is Paul Cain, C-A-I-N. I work for Nevada State Police, Division of Parole and Probation.
Thank you. Please ask the question again.
Did you come into possession of emails between Mr. Handte and former Washington County Deputy DA, Mr. Strala?
Yes, I did.
And how did you come into possession of those?
They were forwarded to me from the Las Vegas office, the author of the report, Ms. Sonia Serena. She's the one who had them all. She forwarded them to me when I requested them.
Did you also come into possession of a text message string between the defendant and a member of the Story County Sheriff's Office?
Correct. And again, that was forwarded to me from the Las Vegas office, staff member Serena.
And do you know the context of any, the Story County situation? Because I believe Mr. Strala now is with Story County as well as the deputy sheriff.
Yeah, I believe he had reached out with concern, had mentioned that they were in the same fraternity back at UNR in the day, worked together in several law enforcement DA cases. Mr. Handte had sent him a text, calling a couple of derogatory names, talking about, I believe, the instant offense case and the defendant, his co-defendant, made a couple of threats about pulling his post certificate, so forth.
And, okay, and was that, I guess, talk to us about the process of someone being sent to probation here, but they're in California being supervised by an officer sort of with with very little connection or no connection to the case.
Well, in Mr. Hante's case, being honest with him in California, you have to abide by his rules and conditions from California, but these oversee his rules and conditions from this court here in Nevada supersede California's. He has to abide by the terms and conditions set forth in his probation agreement that he signed and dated.
Is there someone locally in this area from the division that monitors the California or another state's supervision?
Yes, the Las Vegas office. So when people transfer out of state, the Las Vegas office handles those. It's all communicated through the federal process, interstate compact. For example, Mr. Hante's California supervising officer should be sending review letters basically quarterly, I believe, to the Las Vegas office.
I'm sorry, I asked in this area, like in
in
the
Northern
district
Nevada?
where someone is sentenced, or the region, Northern Nevada, Southern region, that would monitor a Northern Nevada probationer in California.
No.
Okay. And so how does that affect the local probation officer attached to the second judicial district? How does it affect their ability to monitor a out-of-state probationer if they have to go through Las Vegas to get to California?
Point in, case in hand, I was the representative of the division. I now handle the interstate compact division. But again, I'm not familiar with these cases. I just get the report. I represent the division to the best of my knowledge.
And so you, for example, if there were an issue, the contact would be between not a local PO, but a PO in Vegas dealing with all the out-of-state compact people for the entire country.
Well, is Vegas just California compact or Vegas for the whole country?
So anyone in Nevada who interstate compacts out of state is handled through the Las Vegas office.
Okay, so, but that PO in Vegas would not be communicating with you unless it gets this far.
Correct.
Let me ask you, there was a text from, you believe, from Mr. Handte to Mr. Strala, or an email from Mr. Handte to Mr. Strala, or something else?
Mr. Strala had forwarded, well, he emailed the division, I believe, and then he sent screenshots of the text messages from Mr. Handte.
Got it, so both.
Correct.
Okay.
Well, referring now to Exhibit 5, isn't the email, in fact, from Handte to Roy Strala? Don't look at that.
Yeah, if I can. I apologize, Your Honor, I stand corrected, it was the email, not a text.
And then the screenshots, those are from the deputy sheriff in Storytown.
Correct, Mike, my apologies.
I wonder, overall, does the division sort of have like mental health concerns with Mr. Handte while he's on probation?
Not that I'm aware of.
Including, and I just wonder, like, we see a lot of sort of anger and rage and sort of misplaced rage, sort of delusional conspiratorial thinking across the evidence that we're talking about today. Is that sort of a concern for someone to sort of be able to get through probation and lead a productive life as a citizen?
I believe that was brought up last time, and I don't know if the judge had ordered that in the instant offense. A lot of times the judges order a mental health evaluation within 60 days. I'm unclear if that was ordered and whether he followed that order or not.
And just sort of going back to the Vegas point, have you yourself had since contact with Mr. Handte as sort of a, I guess, second tier or third level supervising officer?
No, I've had no contact with Mr. Handte.
Thank you. I'll pass this one.
Mr. Dade?
Thank you. Officer, in the context, referring to exhibit, exhibit 6, the series of text messages between Mr. Handte and Sheriff Mike from Story County, correct?
Correct, Mike Coleman, I believe, was his last name.
Okay. Now, not your, but the division violation report, I'm not trying to pick on you, I know you didn't author this, so. But in the violation report, Officer Serena indicates these messages, these unwanted text messages from June of 2025. You recall that?
Yes,
Okay.
it's in the violation report.
Now, in Exhibit 6, these series of messages, they appear, fair to say, to be largely dated 2024.
I said no. I did not look at the date.
Well, let me.
You may,
Just gonna show you Exhibit 6 here. I'm just gonna point out what I'm looking at.
Yes, March 29th, 2024.
And you can just flip through those pages and look at those timestamps.
Second one of that is say March 29th, 2024. And the last one talking about a Sergeant Joe Welsh is dated April 20th, 2024.
Can I approach again?
yes.
So, again, I know you didn't write this, you don't have a lot of personal knowledge here, but from your review that there's not, do you know if there's an error in the report saying that these are text messages are from 2025 versus 2024?
After reviewing the evidence, yes, I would say it was an error in the violation report.
Okay, so you estimate these are roughly a year old, more than a year old, based on your review?
Correct.
Okay. Now, as far as the context of what precipitated these messages between my client and this sheriff of Story County, do you know the backstory, anything like that?
I do not.
Do you know how long these two have known each other?
There was a reference, but I don't remember. It's been a long time, I believe.
Okay. And you're aware my client was law enforcement officer?
Yes, correct.
Okay. And partially in Story County, right?
Yes.
Okay. Now, email with Mr. Strala. Again, do you know what led to that, the context, backstory, anything like that?
I do not.
And then I guess lastly, you initially answered, Mr. Stege asked you, do you have mental health concerns, my client, you stated no. Is that correct?
At this time, no.
I'll pass it.
Anything else, Mr. Stege?
Do you have concerns about the defendant's use of, for example, the train station reference?
Yes. Had I been Mr. Handte's supervising officer, I would have wrote that technical violation right away. Obviously, I would have articulated it differently, hopefully make sure it was correct, but it's a very, very huge concern, and I would take that as a threat.
Thank you. No further questions.
Anything based on that, question and answer?
Just very briefly, and so when you say articulated differently, what you mean, correct me if I'm wrong, in the violation report, which again, it references a quote TikTok video where Mr. Handte himself is saying, presumably into the camera, time for them to get on the train station, correct?
Correct.
And then here in court, it appears to be Mr. Handte reposting without comment a compilation video from Paramount Plus, right?
On his ex account, correct.
Okay. That's all the question.
Well, the innuendo being he tacitly, adopts the spirit of whatever is contained in those scenes. Is that
Yes.
what you understood it to mean?
Yes, Your Honor.
Okay, that's all. Thank you. Appreciate your testimony. You may step down. Mr. Stege, what else would you like the court to consider?
In terms of evidence, nothing. We want to turn to the defense for potential.
Okay, so let me just tell you this. For purposes of this, I've got testimony from 2 witnesses. I've got your argument. I've got exhibits 1 through 9. The court will consider an aggravation as to why you believe a technical violation of probation has occurred. Mr. Day, what else should the court consider? And you want me to hear from Mr. Handte some more? I'll be happy to put him on the stand. You can ask him anything you want relative to this case.
I just have,
You bet, you take your time. Go ahead.
so first, we would call Tom Allman.
Okay, please come forward. Good afternoon, sir. Welcome to Department 8.
Thank you very much, sir.
Please administer the oath of witness.
Do you solemnly swear or affirm the testimony you are about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am, I did.
Please have a seat right over there. Good afternoon, welcome. Do me a favor, take the microphone and stop. Yeah, it's sort of hanging off the end of the boat there. There you go.
All right.
Please adjust the microphone so it's right in front of your face. Please tell us your name and please spell your last name.
Yes, sir, Your Honor. Thomas D. Allman, A-L-L-M-A-N.
Thank you. You may proceed.
Thank you. Mr. Allman, can you tell the court how you know Stewart Handte?
Sure. I was the elected sheriff of Mendocino County for 4 terms, and in one of the terms, I traveled to Wisconsin for a Native American tribal police seminar, and Mr. Handte was the sheriff of Monroe County at that point, and he and I met at the conference, and we presented together.
All right, so, and that's going back a few years?
Quite a few years, yeah.
Okay. And more recently, Mr. Handte lives with you?
He's my roommate, yes, sir.
He's your roommate, okay. And in the state of California?
In the state of California, the county of Mendocino, in the city of Willits, W-I-L-L-I-T-S.
All right. And approximately how long have you resided together?
Moved in, I think, September of last year. September, October, yes.
And you're aware that Mr. Handte is on probation out of Nevada from this court?
I am.
Okay. And in your time being roommates with Mr. Handte, have you seen him engage in any unlawful activity?
No, he's not an awful activity. He can sit on the porch and tell me the other people who do traffic violations, but that's just what two old cops do.
Right. All right. And in the time you resided together, he's had a job?
He has. He's had several jobs.
Right. And to your knowledge, he's been checking in with his California probation officer?
On a regular basis, and the state officer does come by our house and do inspections and so forth.
And to your knowledge, are they happy with how he's doing on probation?
I've not heard anything to the contrary. They've certainly said that Mr. Handte is a low-risk inspection.
All right. In your time knowing Mr. Handte or residing with him, have you seen him to be a violent person?
No.
Talk to you about plans about killing state officials in the state of Nevada, anything like that?
He wouldn't be staying at my house if he made a comment like that.
Fair to say he has strong feelings about how he was treated in the system, fair to say.
He's expressed those feelings several times, yes.
And as a former lawman, if you believe Mr. Handte was committing a crime, you wouldn't live with them by report of law enforcement?
Both of those would happen.
Thank you, I'll pass it.
Cross-examine.
Have you heard Mr. Handte use violent rhetoric?
Use what rhetoric?
Violent,
Violent rhetoric?
yes.
Could you give me, I mean, he's never told me he's going to hurt someone, shoot someone, kidnap, or, I mean, nothing like that.
What about take someone to the train station?
He's never told me he wants to take someone to the train station, if that's your question. I'm trying to answer specifically, but he's never said anything like that.
Okay. Have you seen the postings on X by your roommate?
I have not.
Okay. Are you guys close?
We're friends,
Okay.
Are we close?
Yeah, it sounds a little interesting that you wouldn't know what's on his socials. You're his roommate, you've known him since he was sheriff of Mineral County.
I am not, I get on social media, but I don't wake up and get on social media, and sometimes I'll go through the whole day without. I think if you look at my, several of my social media, I haven't posted since I was sheriff. I mean, that was part of my past, and
Yeah. That sounds very nice, not just social media.
it's extremely nice.
Now what about, so in the house there where you guys live, Mr. Handte, he has a computer?
In his room, he has a computer.
Okay, and does he talk about sending out the emails that he sends about his case and sort of the cabal?
The cabal,
Yeah.
well, I've certainly heard that word from him, and truth be known, I've certainly asked him to, maybe let me read the email before he sends it out.
Yeah, and because, why?
Why are we sitting here, counsel?
Right, you sort of, it sounds like you're really trying to be a good influence on Mr. Hante's life.
He's a good friend, and I like to, as he has a good influence on me, I would like to be a good influence on him.
Do you think it would be sort of better, I guess, how's he doing overall? Like, how's his demeanor, his sort of trajectory, his,
How's he doing overall?
yeah,
That's a great question.
thanks.
He keeps the house clean, certainly his room clean. He shares in cooking. He treats my friends with dignity. He is involved in the community in ways that I certainly appreciate and support. He's volunteered. My goodness, he takes neighbors' dogs for a walk. I mean, there's not too many things I can say negative about Mr. Handte.
But you would agree that it'd probably be good for Mr. Handte to sort of let you read the emails or to dial back the emails and thinking about the cabal.
Well, cabal is an interesting word, because I mean, I couldn't give you the Webster's Dictionary definition of cabal. Okay, I certainly understand the concept. I heard your question. If you don't mind, I'm gonna answer. The first part, as far as encouraging him to let me read emails, that's fine. I mean, he might ask me, hey, Tom, can I read your emails too before he sent them out? Then we might make a deal. You asked me a question. You didn't ask me my opinion. You asked me a question.
Yeah.
Can I give you my opinion?
How
Hold
about
on,
number?
hold, please. What's your opinion?
Your Honor,
Because it seems like you wanted to tone it down sometimes.
I
That's what
do.
That's a note I wrote to myself here.
I do, Your Honor, but, I mean, he's shared all the evidence with me, and with all due respect to law enforcement, I said in California, this wouldn't be a violation of it, but I've never been a probation officer. I've been a law enforcement officer from deputy up to sheriff, and my opinion is, I don't know why we're here. I'm sorry, but that's my opinion.
Okay, understood. Thank you.
Now, if you will answer my question.
Okay.
You would agree with me that Mr. Handte, it'd be better for Mr. Hante's sort of trajectory and thinking about his future if you were to tone down the rhetoric?
Yes.
And you agree that this is violent rhetoric to say, take someone to the train station?
The judge and I are gonna find ourselves in agreement. I've never watched the darn show. I've heard what, the other witness described it as. I've seen hats and t-shirts, time to go to the train station, but I've never watched the show.
Thank you.
Thank you.
Anything else, Mr. Dave? Before you get up. However this shakes out, it seems like Mr. Handte has a good friend. He's lucky to have him in his life, and I hope that he appreciates what his friend has to offer. So thank you for being here.
Thank you, Your Honor.
Thank you. Mr. Day, who else should we hear from?
Stewart Handte.
Okay, one moment, Mr. Handte, we wipe off the witness station between all witnesses. All right, Mr. Handte, would you please come up here? Have a seat. And then, Mr. Handte, do you understand that you're still under oath?
Correct.
Thank you. Mr. Day, you may go forward.
You. Can you state your full name and spell your last name for the record?
Stewart Handte, Handte.
Thank you. And Mr. Handte, prior to coming to court today, you've reviewed the technical violation report that's filed in this case.
Numerous times, yes.
All right. So, just kind of give you a roadmap, we're gonna go through that kind of in order.
I can make this easy for everyone.
Sure.
I really like him to dial into communications with the district attorney, any court official, any judicial officer, and the posting or reposting of the video from Yellowstone.
Well, all right, so let me get right to some of the points here. In Exhibit 6, those 2024 text messages with the sheriff of Stewart County. How do you know him?
I've known Mike Cullen for approximately between 5 and 10 years. I actually went up to Story County after I had been a deputy sheriff there for 2 stints and actually campaigned for him when he was running against his opponent, who was Gerald Antonoro.
All right, and fair to say, 2024, you texted him a few different times?
Correct.
Okay. Those text messages that are in Exhibit 6, is that are those 3 out of 500 messages that you sent, or is that the sum total of what you communicated to this individual?
That would be the sum total. I did not text message him more than what's been indicated
Okay.
in the reproduction of those text messages.
Okay. And in your communication with him, fair to say you disagreed with the course of action he was taking, and you wanted to let him know that?
I believe that it was in his best opinion, from a legal standpoint, to disregard the pending case against my former co-defendant. And
Okay.
since I worked up there, I knew a little bit of the backdrop behind the political and legal ramifications of that county.
Oh, and at some point, he was not replying to you, you stopped reaching out to him?
Correct.
Okay.
I was instructed after the June 6th, or June 12th, sorry, text message, not to reach out to him anymore by my California supervising officer, the only time I've been talked to by my California supervising officer, and I agreed, and that was it. That's where it stopped.
And in any of those messages, was your intention to make this individual fear for his safety, his life, anything like that?
Absolutely not.
Was your intention to harass him or cause him mental anguish?
No, sir.
All right. Now, this email to Mr. Strala, how long have you known Mr. Strala?
Since 1979,
And back then, you went to college with him?
I did. We both belonged to the same fraternity.
Now, can you explain briefly what led you to want to send him an email?
I was made aware of a video that took place in the Virginia City Justice Court where Mr. Strala, representing the state, brought my name into a legal hearing that had no direct or indirect connection to me. And that was reprehensible conduct as far as I was concerned.
And so it was video available to you on YouTube?
It is.
Okay. And was it a criminal prosecution?
It was.
But not involving you?
Correct.
Okay. And so what I hear you say is you watched that video, heard your name mentioned, that was offensive to you?
Very offensive.
Okay. And as a result of that, you send a strongly worded email to Mr. Strala?
I viewed my opinion in that email correct.
Okay. And again, that's the court's edification exhibit 5. To be clear, when you sent that email to Mr. Strala, was your intention to make him fear for his safety, make him feel threatened, anything like that?
No, just to call him out.
Was this one email out of 100 you sent him, or is this the sum total of your communication for us?
Sum total wanting email.
Okay. more things before we wrap it up here. To be clear, you did not make a TikTok video talking about people getting on, specific people, time for them to get on the train station?
There is no TikTok video that exists
Okay.
regarding that.
Other allegations report that in April 2025, you were harassing your father's guardian. Is that accurate?
That is most disturbing to me because my father passed away October 21st of 2006.
Okay.
So my father did not have a legal guardian. I don't know who Laura Gray is, nor do I know who Lila Fons is, and none of that is in the documented verified complaint form, which is in compliance with the rules and regulations set forth in the NIA.
And so, fair to say, as to that allegation, doesn't make any sense to you?
That's ludicrous.
Just touching on the subject very quickly as to the fines and fees, is it your intention to timely pay all the fines and fees associated with this case?
Yeah, I'm currently, as the judge knows, I'm currently out of work and seeking employment. I've also applied for Social Security disability benefits because of a medical condition that I'm not going to discuss in this courtroom, nor should anybody else. So I'm trying my best to get gainfully employed, or in the opposite of that, to be placed on Social Security disability. And once I'm able to do that, then I'll be able to catch up and get ahead and pay all my fines that are done. I have paid $1,064 for the quote-unquote extradition fees. That's paid in full.
And in your work with your California probation officer, to your knowledge, is he happy with your compliance?
Yes, as I stated earlier to Judge, he was recommending to Nevada that I be released off probation early because of my compliance with the rules and regulations set forth in California, where I am a resident of as of the state.
All right. And again, lastly, big picture here, in any of the discussions or communications we've talked about in court today, was your intention at any point to make any individuals feel threatened for their safety, their life, anything like that?
No, I don't know where they get that mindset from, but most of my correspondences have that moniker on there that I'm not there to incite violence. I'm just there to voice my opinion, which is entitled to me under the First Amendment.
And without going into all the specifics, fair to say you have various grievances against government in different forms.
Absolutely. This entire 6-year process case against me is total miscarriage of justice.
That's all. Pass the witness.
Thank you. Examination by the state.
So you had Mr. Strawless said your name in court up in Story County, is that correct?
Absolutely correct.
And in what context, or where did he say it?
Basically, he was bringing my name into a court hearing that I had no direct or indirect connection to, talking about me involving with Mr. Hilligus, which was my former co-defendant in this court.
Okay. Okay, so, but you think Mr. Strawless knew that you guys were co-defendants and friends and allies?
Of course he did,
Yeah, and so he brought that up in court.
for no legal reason whatsoever except to harass, embarrass, and intimidate me in a court hearing that I had no direct or indirect connection to.
So,
Correct.
what was it that he said? That,
The mere mention of my name, Mr. Stege,
Okay.
is reprehensible.
okay,
That has no business being brought to a hearing that I had no connection to.
so reprehensible, that is, that's your word.
That's reprehensible.
Okay. He also said he brought up to intimidate you.
I believe that's a form of intimidation by him. Yes.
Okay, and how did it intimidate you?
Bringing my name back into a court arena that didn't need to be done. I've tried to better myself by going to California, living with Mr. Allman,
Okay.
and my name being brought back through the mud again is totally disgusting legal contact.
And totally intimidating to you.
Intimidating to me based on everything that's happened to me in the last 6 years, absolutely.
Okay, so Roy Straw is saying the name Stewart Handte intimidating, right?
Yeah. Absolutely.
Okay.
Dragging my name through the mud again.
Let's talk about your X account. You don't post a whole lot, do you?
No, that's actually a private account, so I'm kind of curious how people are able to access that account.
Okay,
Same for my TikTok account.
okay. Remember what I asked you?
Specifically what, sir?
You don't post very often, do you?
Not very often, no.
In fact,
Let me take that back. Maybe between not very often to often in that area.
you seen the exhibits we've been talking about
I
today?
have.
It's got your, it's like you're a young trooper, got a picture of yourself there. Stewart Handte.
In better days of law enforcement, that's correct.
Better days for you then, right?
That's argumentative. New question, please.
And your handle, ex-state trooper. That's your handle.
That's the title I most admire, despite the fact I've worked in five other law enforcement capacities, correct?
And so you agree that, or you don't dispute that you posted on August 1st, every visit to the train station with the YouTube link?
I don't disagree with that at all. I reposted it, but I didn't add anything to it.
Okay.
I believe I was having a discussion with a friend of mine about the series Yellowstone, which I've only seen bits and pieces of.
Okay, hold right there. So, Mr. Handte, now that you understand why we're here and the concern, do you understand why that might get some people a little bit worried?
Well, Judge, it depends on whose opinion you're talking to. Some people could get scared by you yelling boo at them, and some people would not be intimidated, says, I want to walk up with his gun and point it right at your head. It just varies from person to person.
I know, but but here's the thing, you understand you're on probation.
I
and you're not
understand
supposed to. Okay, and you understand you're not to directly incite violence or, indirectly. And so the argument here, of course, you're a smart guy, you
I don't know
understand.
about that anymore.
Well, you're a clever man, and you understand the concern by the state, the division, the court, that this is indirectly doing something you're not allowed to do directly. Do you understand that if this hearing goes your way, and there's no violation found, it's gonna be people are gonna be dialed into how you say things, what you repost, the
I get that
implications.
now.
You get that now?
Yeah, I get that now.
Okay, please, next question.
Okay, so you agree with the court and everyone who's testified that referencing taking someone to the train station refers to death?
No, I disagree, because there is a train station in Reno, and there's been times where I told people, get on the train and get out of town, because
Okay.
you're not good for this community.
Well, hold on.
So,
You're losing a little credibility here, Mr. Handte, because you're not trying to insult the court
I'm not
situation.
insulting the court.
But it's yet from the Yellowstone clip, it's a composite.
Or you agree that that's what it means from the clip?
In that clip, in that series, I believe you're probably correct. In that clip, in that series.
Yes, in fact, that clip shows every instance where they say, taking to the train station, and they go and murder someone out in the wilderness.
Or they dispose of the body. But
Yes.
Okay.
You agree with that?
Actually, if you watch the clip, not everybody is taken to the train station.
Okay.
Now we're splitting hairs. All right, let's move on. The court understands each side's.
Okay, but, so you agree, right, that murder, death, killing, getting rid of somebody,
I agree what?
that's what that means?
Mr. Stege, let's go to a new topic.
Okay, so you posted that video, you don't deny that?
No, I don't.
And you don't deny that you forward a post to Mr. Hicks on the Max PEIN on X?
What is the max PEIN? Is that the video talking about financial?
Yes.
Yeah.
Yes. In fact, and then, remember what you wrote in that email?
Not unless it's sitting in front of me, I don't know word for word.
Okay. Did you in fact write, some of them actually deserve a ride to the train station for what they have done, exclamation point.
Downtown Reno, correct.
And then you wrote, hey Reno Police, Washoe County Sheriff, ... Washoe County District Attorney's Office, Reno Justice Court, you wrote that.
I did,
And the Second Judicial District Court, you
I
wrote
did.
that. Y'all might want to take a gander at this.
At the video.
And so, is that reprehensible? Threatening someone to take them to the train station?
Wait a minute, we're talking about the video, the EPIN or whatever that is. That has to do with financial doings. That doesn't sub-reference to the train station.
So for financial doing, should people be taken to the train station?
You're asking me, in your context, should people be murdered for financial doings? And the answer to that is no.
Is it reprehensible to suggest that someone should be taken to the train station for,
Not if they need to be taken out of town on the train. Amtrak runs through Reno regularly. I know that because I've lived here 50 years,
now, Mr. Handte,
or I did live here, sorry.
Stu, you know that the issue
Yes,
of
yes.
credibility, you're running into that again.
Well, and we can discuss credibility as well. When you contacted me on Friday, which was totally illegal.
Let me ask you something, what's more reprehensible? A lawyer in court saying your name, or you